Did you know that if something bad happens to you in the hospital, there's a good chance that your case is going to be brought up at the Mortality and Morbidity conference at the hospital? The question for you to answer is, can we use that if you bring a lawsuit against the hospital? You want to learn the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. That's often known as an M&M conference. Now, the doctors who are involved in your care and treatment gather each and every week. And there's a select committee known as the M&M Conference. Let's say you suffer a bad complication because of somebody's carelessness at the hospital. Now, if your matter is presented during the course of this Mortality and Morbidity Conference to other doctors, and now they brainstorm and figure out what was done wrong and what can be done in the future to prevent this from happening, can we get information about what was discussed? If notes are taken, if there's a transcript, can we get that information to then use at the time of trial to show to a jury? Ladies and gentlemen, look what these doctors discussed. Look at their analysis here. Look to see what they felt about the doctors and the staff being careless, and as a result of that, caused this patient harm and injury. Can we use that information? The answer is, no, we can't. That information that you discuss at that meeting is privileged, which means that I, as an attorney who represents an injured victim, cannot get information about what it was that they discussed. I cannot gain notes about information that may have been transcribed at that meeting. But there is one or two exceptions where I might be able to. But the reality is, in most every instance, that is privileged and protected material. And no matter how much I ask doctors or hospital staff during depositions, during pretrial testimony, about what was discussed during those meetings, the answer I get every single time from the defense attorney is, objection! That's privileged information. You cannot get that information. And according to the law as it exists today in New York in August of 2014, that's exactly what we're faced with. So why do I share this quick tidbit of information with you? I share it with you just to give you an insight and understanding into what goes on when evaluating and strategizing what to do in a medical malpractice case here in New York. Yet I realize you're watching this because you have questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. This is something I do every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a great day.